Hi, I'm Dan Chambers of Chambers Law Firm. In this particular video, I'm going to talk about something that a lot of people don't even know exists, and that's the concept of the death penalty in federal court. Now, many of us have heard of the death penalty in state court. California has a death penalty statute and has a death penalty punishment available, although it's rarely exercised in California. And in the Deep South, they still have the death penalty. In many other parts of the country, they've outlawed it. However, in federal court, there is the death penalty. So you can be charged in federal court with certain federal crimes and face the death penalty. And that's something a lot of people don't know. But with respect to what qualifies you for a potential death penalty in federal court, it's very similar to, for example, what we have in California in terms of the crimes that qualify. Under federal law, any type of first-degree murder, as defined by federal law, can expose the defendant to the potential of the death penalty. So, for first-degree murder, treason, certain types of espionage, you are what we call death eligible, right? Kind of a weird term, but it's a death eligible crime. Now, here's where it gets interesting. Under federal law, only the U.S. attorney, the big boss in Washington, can decide whether the death penalty is going to be sought. A local prosecutor, a local AUSA, as I call him, assistant U.S. attorney, has to go up the ladder of command to get approval to seek the death penalty. Now, once that approval is given, the prosecutor is then required to give the defense what are called a statement of aggravation or statement of aggravated factors. It's a written document given to the defense attorneys saying, here are all of the reasons we think this is an aggravated crime that warrants the death penalty. And that allows the defense to then go to work on finding what are called mitigating circumstances. Because at the end of the day, a jury has to weigh those two, the aggravating and mitigating factors, and a jury is going to decide whether that defendant is going to be sentenced to death. Aggravating factors can be things like, what is the person's prior criminal history? Do they have prior violence? Have they been convicted of multiple crimes? And things like that. Mitigating factors can be things like maybe there was something in that person's childhood, a developmental disorder, or a cognitive problem that has led them to the behavior that they've engaged in. And the defense attorneys spend a lot of time on what we call mitigation. But at the end of the day, it's up to the jury to weigh those factors and impose an appropriate penalty. So there is, in fact, federal death penalty. And here's an interesting little wrinkle. If the defendant is sentenced in a state that does not have its own death penalty, the U.S. Marshal has to transport that defendant to a different jurisdiction that does have the death penalty to actually execute the sentence. Now, all death penalty sentences obviously are the subject of an appeal to a higher court and can sometimes get overturned on an appeal. But the federal death penalty is a real thing, and the U.S. Attorney still prosecutes them, particularly nowadays under racketeering activities. You're seeing it a lot with gang members who are accused of running a criminal enterprise that involves drugs, human trafficking, and ultimately homicide if they put out what they call a green light on somebody. These organized criminal enterprises are now the subject of the U.S. Attorney going after and seeking the death penalty. If you or a loved one is facing a crime that you think is a death-eligible crime or a very serious crime that could expose that defendant to the death penalty, give us a call. We'll be happy to talk you through what the landscape looks like and provide you with up-to-date advice on what you can do. And we always provide a free consultation, so please give us a call. Thank you.